The defense team in the Kyle Rittenhouse trial called a use of force expert to the stand today. The 18-year-old defendant took the stand in his own defense yesterday. He got emotional when discussing the moments leading to the shooting of the three men during a protest last year. Two of the men died. Rittenhouse told jurors he shot them in self-defense and had no intentions of killing anyone. At one point, the judge called a recess and rebuked prosecutors for what he called, quote, an improper line of questioning. That has prompted calls for a mistrial with prejudice. The judge did not rule on the motion, but if he grants it, Rittenhouse would not face a retrial. For more on this, I want to bring in CBS News legal contributor Rebecca Roiphe. Hi, Rebecca. Thank you for being with us. So, some of the prosecutor's questions to Rittenhouse during cross-examination yesterday angered the judge. But do you think what the prosecution did was enough for the defense to seek a mistrial with prejudice?
You know, what the prosecution did was essentially two things that were inappropriate. First of all, the prosecution implied that Kyle Rittenhouse hadn't come forward earlier and established his self-defense claim earlier, and that is in essence commenting on his silence, which violates your Fifth Amendment privilege against compelled self-incrimination. And so the judge was angry about that. The prosecution also elicited some discussion about some evidence that the judge had already ruled was inadmissible because it wasn't relevant. And so that provoked the anger of the judge and then led the defense to ask for this mistrial. Now, I actually don't think that the judge is going to grant it, in part because judges tend to not to take things out of the hands of the jury. And the jury has already sat here and listened to this case. It's an extreme case where a judge will say this is so egregious that we're not going to allow the case to go to a jury and the decision to be made.
So for those who don't know, for those of us who are not legal experts, explain the differences between a mistrial and a mistrial with prejudice.
Sure. A mistrial just means that it ends here. This particular trial is over. This particular jury will not deliberate and will not issue a decision, conviction or not guilty. Instead, they will start, the prosecution is free to start all over again, which means they file charges again. They have a new process in which they impanel a new jury and they go to trial again. So that's a regular mistrial. A mistrial with prejudice is when the prosecution is not allowed to even try again. So they can't convene that new jury. They can't bring him to trial again. The case is just over. It almost has the same consequences as a not guilty verdict.
That's a pretty extreme end. All right, so Kyle Rittenhouse's defense is calling on several more witnesses today. How do you think these witnesses will fare in their efforts to bolster the defense's argument of self-defense, not just once, but 3 times that Rittenhouse fired his gun, killing 2 people and injuring another, especially considered there were many people armed on the streets that night and none of them discharged their weapons?
Right. I think, frankly, that this case was over when Rittenhouse testified, and I think the jury made its decision at that point. Now, that's not to say that these experts and other witnesses are not important, but I think it comes down to whether or not the jury believes Kyle Rittenhouse about his state of mind. As you were mentioning, the prosecution introduced some evidence that made that claim implausible, but it's very hard to prove beyond a reasonable doubt that somebody did not reasonably think that their life was in danger, and that's the position that the prosecution is in here. And so I really think it comes, when he broke down in tears yesterday, when he said, I did this because I was afraid for my life, did the jury believe him or didn't they? And I think these other experts, sure, they will help, but I think it almost is irrelevant because I imagine that the jury has at this point made up its mind.
And Rebecca, in general, when you have a witness testifying in his or her own defense and they have such an emotional response, like the one that we saw from Rittenhouse, does that tend to bolster the defendant's case?
It really depends on the witness, because I think it's true that in some ways, the jury is waiting to hear from this person who has been the subject of this trial, and the person takes the stand and they're waiting to see what kind of person is this. And if the defendant can get the sympathy of the jury, the empathy of the jury, can make them feel what he feels and can make him human, then that is a step for the defense, a significant one. On the other hand, if it feels like this was hammed up in some way, acting in some way, trying to get sympathy, it could backfire. So it really, again, depends on how they saw those tears. Were they real tears? Was it that, he's a real child who was there, and afraid for his life? Or was this somebody, who had provoked this situation and in some way wanted to encounter this situation and himself was responsible for setting it up? And it really depends on how those tears came across to the jury.
Right, because then, of course, you also have to imagine, the families of the two dead men also have, similar emotions that simply are not on display in the courthouse.
Right. I mean, and, the prosecution, I think, tries to bring those up, but has less leeway, obviously, because you can't, call them or call their family members to talk about that kind of thing. And that's important because those emotions are not really supposed to be part of the conviction. But at the same time, this is relevant and it's important. And it really, this verdict hinges on what they thought about those tears.
Absolutely. All right. Well, Rebecca Roiphe, thank you so much for joining. As always, we appreciate your legal insight.
Thank you so much.